Hello and welcome to Topic 9, Lecture 2. And in this lecture, we are going to be looking at the personnel that work in the courts. So what are we going to be covering in this lecture? Well, we're going to learn about prosecutors. We're going to learn about the different types of prosecutors, their duties, and the concept of prosecutorial discretion, which you're actually reading about in the book Locked In for your paper that's due this week. We'll also be learning about defense attorneys, different types, their duties, and the ways in which defense attorneys are assigned, particularly for those who cannot afford a defense attorney. Now, there's obviously other court personnel that the textbook talks about. And so just keep in mind that you're responsible for reading about judges in the textbook, okay? So there will be questions on the quiz about judges, and you'd also be responsible for that material for the upcoming final exam. So that's what we've got on the docket. Let's get started. Okay, so courtroom personnel. Who inhabits the courts? Well, regardless of the type of court, there are certain players that fulfill a specific function. As you know, in the last lecture, we learned about that there are different types of courts. On the one hand, there are federal courts that deal with federal matters, and then there are state courts that deal with state criminal law and civil law. We also know that there are trial courts, appellate courts, and Supreme Courts. And so regardless of all those different types of courts, there are certain players in all of those courts that fulfill a specific function. And that function may be different depending on whether it's a trial court, an appellate court, or a Supreme Court. In courts, you find prosecutors, you find defense attorneys, you find judges. And so obviously at trial courts, you're going to see a lot of the prosecutors, defense attorneys, and judges actually in action because that's where the trial takes place. However, in appellate courts, that obviously you have judges because they're the ones who are deciding whether or not there were errors at the trial court level. But prosecutors and defense attorneys, particularly for criminal matters, are present as well. Because if a person disputes their verdict and say that there were errors in the trial court, the prosecutor is going to be there defending the state, arguing that there were not errors there. And while we don't necessarily have prosecutors and defense attorneys at Supreme Courts, particularly the United States Supreme Court, there you have judges, and then you'll have people who will come, plaintiffs, those who have complaints, and those who are responding to those complaints, so respondents, but that they definitely could have backgrounds that include defense attorneys and prosecutors. So you do see these courtroom personnel in all levels of our court system. There's obviously other personnel as well, court clerks, bailiff, court reporters. And so, that when we talk about the courtroom work group, we're mostly talking about prosecutors, defense attorneys, and judges. But those other personnel also contribute to that sort of the shared norms and values that we talked about earlier in this semester. So let's focus now on prosecutors and defense attorneys. Okay, so let's talk about the different types of prosecutors you'll be reading about in your textbook. So there are two main types of prosecutors. One is known as the United States attorneys, and that these are prosecutors who work on the federal side of things. And so that if there is a federal crime and somebody is going to be charged with a federal crime, then it's the U.S. Attorney that would be in charge of investigating that federal crime and then deciding whether or not that person's charged, and then representing the United States government if that case goes to trial. United States attorneys work in the trial courts, the U.S. district courts. They would also represent the United States in the appellate courts as well. U.S. attorneys are not elected. They are nominated by the president and confirmed by the United States Senate. They don't necessarily have a term, but usually the thinking is that they serve at the pleasure of the president. And so that when there's a new president, that it can be expected that a United States attorney might render they might tender their resignation with full knowledge that the new president is probably going to put in some new U.S. attorneys. It doesn't always happen. There's sometimes some carryover, but that can happen. The other type of prosecutor is what's known as district attorneys, and those are prosecutors at the state level. And in Wisconsin, our district attorneys are at the county level. And so John Chisholm is the Milwaukee district attorney. He's been in office for a long period of time. And the Waukesha district attorney is Susan Opper. These positions are both elected to 4-year terms, and that, as they talk about in the book Locked In, that, if you don't like your prosecutor and what they're pursuing, then get actively involved, because we get what we vote for, or really we get what we don't vote for, because a lot of people don't participate in these elections or don't think about them. And so since they are elected, look at the job they're doing, and that you have an opportunity to weigh in about whether or not you want that prosecutor to continue on as your district attorney. Okay, so what are the duties of the prosecutor? Well, the prosecutor represents the state, okay? And so that, as we know from the semester, that once somebody is arrested and, brought into custody, at that point, it kind of turns over to the prosecutor. And the prosecutor is sort of like the top law enforcement individual. And then, that they're basically representing an offense against the state or against the United States if you're a U.S. attorney. And so, one of the things that prosecutors do is they investigate violations of the law. And so they can be a part of that investigatory process. They get tips about, crimes that are taking place. They'll work with law enforcement to engage in an investigation to see if you can identify who's responsible for this crime, and then ultimately arresting them and charging them. Prosecutors, you'll read about in your textbook that they can be proactive or reactive. And so reactive is where you hear about a crime and then you engage in an investigation. But proactive could say, look, this is something that we're really concerned about in our community. You could say that maybe there's a concern regarding, like in Milwaukee, the vehicle thefts and, the joyriding, the so-called joyriding that's going on, but that's actually been resulting in a lot of harm. And so there can be a proactive sort of approach to sort of say, this is something that the prosecutor's office wants to sort of focus more on. The prosecutor files formal charges against an individual. And so in a bit, we're going to be talking about prosecutorial discretion. And it's also something that they talk about in the book Locked In. That they interview witnesses in criminal cases to decide whether or not formal charges should be leveled. And then because they are representing the state, they basically, when somebody is charged with the crime, then it's their responsibility to represent the state at the trial, at the criminal cases. That they, any sort of pretrial activities that go on, the state will be there. So for the arraignment, the preliminary hearing, if you use a grand jury system, the prosecutor would obviously be involved in those. If there's any plea bargaining negotiations that go on, obviously the prosecutor is going to be involved in that. Prosecutors recommend sentences, and then also that if there is an appeal, then the prosecutor would represent the government, the state, or the United States in that appellate process. And so you can read in more detail about each of those duties, but that's kind of an overview of the duties of the prosecutor. So as you know from what we've learned through the course of this semester is that just because somebody is arrested for a crime doesn't mean they're necessarily going to be charged with a crime. And in fact, when you think about the funnel, there are a lot of people that, are never charged and then they're just released at that point. And so, that's what's known as prosecutorial discretion, that prosecutors have this broad discretion over case rejection or dismissal. They can basically say that even though this person was arrested, that we're not going to pursue this case, that we're not going to issue charges. And as we know from earlier in the semester, that's called nolli prosequi. Basically means that the prosecutor is unwilling to pursue this case. The Supreme Court, in a way, was, that could be sort of dangerous, just like any kind of discretion, right? That bias could work its way into that discretion. And so just with law enforcement, we see the discretion about who to pull over in a car, who not to, who to frisk in a Terry search, who not to. There's oftentimes improper exercising of, racial or gender or age bias in terms of that discretion. Well, so, that because prosecutors have that discretion, that about what cases they want to pursue, that could be that maybe some cases really need to be pursued and they're not. And it would be nice if there was sort of a check on that balance, that power of the decision not to pursue a case. However, the Supreme Court, that question has come to the Supreme Court, and that they've considered this issue about, is there a check on the prosecutorial discretion to not pursue a case, and they concluded that that district attorneys, prosecutors do have these broad discretions to make decisions about which cases they want to pursue and which they do not want to pursue. Thus, the decision to drop is rarely, if ever, reviewed by an upper level court, an appellate court. And that doesn't mean that there's no consequence. There, may be a consequence, obviously, at the ballot box, since district attorneys at the state level are elected. But there can also be a consequence for that if you're a U.S. attorney. If you're not pursuing cases that that the Attorney General of the United States thinks should be pursued, you could be pressured to pursue those cases, or that there could be a negative consequence that could come. You could be fired. And so there are some checks on those, although there's not sort of a legal Supreme Court sort of like, oversight on that, saying that we have this right to check prosecutorial power. We do not, according to the Supreme Court. So in terms of exercising prosecutorial discretion, your textbook talks about 4 factors that oftentimes govern the decision a prosecutor makes about whether or not they want to pursue a case. And so those 4 factors are system factors, case factors, disposition factors, and political factors. So let's look at each of these in more detail. And then after we learn about these, there's 2 hypotheticals that we're going to take a look at, where you will have an opportunity to apply these factors that impact prosecutorial discretion. Okay, so one factor that prosecutors take into consideration when they're deciding whether to pursue charges is what's known as system factors. And what system factors are is basically the features of the court system. And so, that there might be certain features of the court system that may factor into the decision that a prosecutor might make in terms of, should I pursue this case or not? So what are some examples of system factors? Well, it costs a lot of money to pursue, if you charge somebody with a crime, then you've got to be prepared to take that case to trial, because once you charge somebody with a crime, there's no guarantee that they're going to plead guilty. They may plead not guilty. They may decide that they don't want to engage in plea negotiations. So that basically means when you charge somebody, you've got to be prepared to go to trial, because that could happen. And going to trial is incredibly costly. It's costly in terms of the people power it takes to prepare for trial. And so district attorneys have offices with lots of assistant district attorneys in them. And so, and as we know, there are tons of cases that work their way through the system. And so if you've got to say, what are the costs associated with this? How much investigation is going to go on? If it goes to trial, how much time is this going to take? And so those are all system factors that could be taken into consideration. You might look at the backlog that your office has, right? If you already have a lot of cases that have been charged and are pending trial or in the process of plea negotiations, you might say, God, we have such a backlog right now that we just can't not, given the resources that we have, we just cannot take on another case. And so that particularly this system factors are going to be taken into consideration when it comes to less serious offenses. So again, remember the criminal justice wedding cake. Remember, it's sort of like the serious cases are the ones that are most likely to go through all the steps, right? And so that a less serious case, you might just say, we just don't have the time, the money, the resources to pursue that. And so, and they might say it's better the time is better spent on more serious cases that are presenting much more obvious harm to our community. Other factors that prosecutors take into consideration are case factors. And so case factors are features of the specific case. And so as prosecutors are looking at a specific case, they may look at those features, and that could influence whether or not they decide to charge an individual with a crime. Some examples of case factors are obviously strength of evidence. And so that since if you charge somebody, you could go to trial, you want to win it if it goes to trial, right? You want to get a conviction. And to get a conviction, you need really good evidence, right? So let's say that most of the evidence is circumstantial and there's no real evidence in terms of forensic evidence of fingerprints or blood spatters, there's no confession. Let's say that there's no eyewitnesses, or the eyewitnesses that are there. Let's say it's a video, we have videotape, good, but if it's eyewitnesses are, can be quite unreliable. So you look at the strength of evidence, and you might think that this person should be charged, but based on the evidence, you may not get a conviction. And so that can be something that is taken into consideration by prosecutors. If the suspect is willing to cooperate, so the person who is potentially going to be charged with a crime, if they are sitting down and talking to law enforcement, if they seem to, be participating in the investigatory process, that's something a prosecutor could take into consideration, because that's going to give them more evidence. But if the person is pleading the fifth, if they are remaining silent, if they are really not cooperating at all, that's going to make the prosecutor's job more difficult. And then also the prosecutor, when it comes to case factors, might look at the relationship of the victims to the accused. And so if the accused is, if the victims are strangers, that's probably better in terms of case factors, because there's no reason. I mean, if you were robbed, there would be no reason why you wouldn't want to testify against this individual, because you don't know that individual. Now, I mean, let's say that individual is involved in a gang or is a mobster or something like that. You might not know them, but you know of them. And again, that would be probably a reason why you wouldn't pursue. But if the accused relationship to the victim is a friend, a spouse, a child, a neighbor, a niece, whatever, that it might be that you couldn't rely on that victim's testimony, because they might they might decide that they don't want to participate, and then even if they are subpoenaed, that they may not be real forthcoming in terms of the kind of evidence that they're going to give. And so that would, again, be something that the prosecutor would take into consideration. Your textbook talks about disposition factors, and basically what that means is that that when a prosecutor looks at a case, they might say there's a better way of disposing with this case than charging an individual and then preparing for trial. So there are better ways of handling this than charging and trying. And so your textbook talks about the concept of pretrial diversion. That's basically where a prosecutor says, you know what, we're going to charge you with a crime, but that we're going to hold off on actually acting through, following through with those charges. And that if you do certain things like get a job or go through anger management therapy or get drug rehab, if you satisfy those terms, then we will drop the charges, and that will be the end of it. And so that can be something that that you don't really charge, that you're willing to dismiss the charges if other sort of criteria are satisfied, and then if they are satisfied, then the charges would basically be dropped. Okay, the final factors that we're going to look at for prosecutorial discretion are political factors. State prosecutors are often elected and they're accountable to the people, okay? As such, that public opinion and scrutiny that a prosecutor might be getting from the media, or just knowing that an election is coming up, can play a role in deciding whether you want to charge someone with a crime. And so these political factors may be taken into consideration in exercising discretion. The prosecutor may feel pressure to pursue or not pursue something based on an upcoming election. And so that let's say that that somebody who's really popular within the community is maybe engaged in a criminal act that you might feel like, boy, if I charge that person, I'm going to get a lot of blowback from that. On the flip side of that, there might be pressure to take action, right? Let's say that there's somebody in the community who is, people don't like, or they feel like they've been harmful to the community. There might be pressure to do something about that. Pressure because you don't want to lose the upcoming election. Anytime there's sort of any public outrage about an issue or media scrutiny about an issue, it kind of forces the prosecutor to maybe pursue charges. An example, I just recently watched the Alex Gibney documentary about Elizabeth Holmes and Theranos, that blood healthcare startup company. And you really, that the Wall Street Journal got tips from people who worked at Theranos, and ran stories about Theranos, about how fraudulent their activities were. And then that media scrutiny that Theranos got, that led it to the federal prosecutors to take action, right? They didn't really have a choice. And so prior to that, that there were a lot of famous people on the board, and even though if there were some rumblings of fraud, George Stoltz, General Mattis were on the board, and you might be like, the prosecutor might be, I don't want to upset those people, so even though we're hearing about fraud, we're not going to do anything about it, okay? So those are just some examples of the political factors that might influence prosecutorial discretion. Okay, so now let's apply what we've learned as a prosecutor. So let's say you're thinking about pursuing some charges in this file. We're going to look at two hypotheticals. And here's some things to keep in mind. That you're up for re-election in about a month. And your opponent is closely monitoring all the decisions you're making so that they can use it against you in these final months of the campaign. You have a really small office. You only have 2 assistant prosecutors. So that is sort of a system factor you have to keep in mind about pursuing cases. You don't have a lot of people working under you. So be cautious about the cases that you take. And also your county jail is really overcrowded. That if you charge somebody and they don't make bail, you're going to have to house them at your county facility. And right now you can only house 2 more defendants. Okay. So those are some of the constraints that are placed upon you. And so if they're charged, they can't make bail, you got to open up a spot. Okay. So these are some of the factors that are system factors that are weighing down on the prosecutor. So let's take a look at the 2 hypotheticals and see what you might take into consideration. Okay, so let's apply the concepts here. So here's the case study. So the case is that a 19-year-old son of a wealthy doctor is arrested for a 3rd drunk driving offense. There was a minor in the car as well, and in Wisconsin, a 3rd offense with a minor in the vehicle is a felony offense and can carry over a year in prison. Now, the wealthy doctor, the father of the person who engaged in the drunk driving, usually contributes to your campaign. And so, your election's coming up, they usually contribute to your campaign. So you might not want to, arrest or charge their son with a felony because you might lose that campaign contribution. But if you don't do that, then it could also hurt you because remember, your opponent is really following your every move. The normal policy is to refuse plea deals to a chronic 3rd-time offense so they can actually do jail time. But the defense attorney says that they can get a quick guilty plea if the charges are reduced to reckless driving and agree to probation, not jail time. Okay. So here, this is prosecutorial discretion and not deciding not to pursue the case, but charging somebody with a lesser offense. So what do you do? And what factors do you take into consideration? And so you can think about this. And I guess you could say definitely there's some system factors that you would take into consideration, that pursuing this, felony, they may not, if you charge them with a felony, they may not plead guilty. You might need to go to trial. You already have you only have two people working under you. And also political factors. If you go light on this person, that's going to hurt you. If you don't charge them with a felony, then that's going to hurt you because your opponent might use that against you. But then that's going to have some impact for your system as well in terms of your lack of people power to pursue the case. All right, how about this case? The case is that there's an underage person, 17 years old, arrested for shooting their father with a hunting rifle. They claim it was an accident. So the shooter claims it was an accident. The father is in a coma and is unable to be interviewed or contribute to the investigation. There were no other witnesses in the hunting accident or crime. That it was just the boy and his father. But the mother, says that she wants her son to be charged and held in jail because she feels that he's really dangerous because she doesn't think it was an accident. She thinks that her son has, sociopathic tendencies and is a danger, has sort of talked about killing his dad, and it happened. So the mother really thinks that the prosecutor needs to do something about this. So what do you do and what factors do you consider? What are some of the case factors you might consider here? Now, one of the things we talked about is the amount of evidence, the fact that there are no other witnesses and one of the witnesses is in a coma, that might play a role. The fact that they have a relationship, the mom and the son, can you really depend on that individual to testify? They might change their mind. They might become a reluctant witness. System factors, that this is a serious crime, so this person probably wouldn't be able to meet bail. And again, this would, if they don't plead guilty, there would be a lot of work associated with this. All right, those are just some examples because as we move forward, that a case study like this may show up on the final exam for you to sort of work with. So both defense attorneys and prosecutors are officers of the court. This we know. However, they have very different focuses. Prosecutors, as we were just talking about, they enforce the law, but they also are obligated to seek justice, okay, because they defend the state, but they have to uphold the principles of justice and due process. So, for example, if a prosecutor comes across exculpatory evidence, they have to turn that over to the court. If they find evidence that basically exonerates the individual who was charged with the crime, they have to turn that over because, they cannot knowingly falsely charge or try somebody. And so if you get evidence that exonerates an individual, indicates that they are not the person who engaged in this crime, they have to turn it over in the name of justice. Defense attorneys, it's sort of a different goal, that their job is to provide defense to the best of their ability for the criminally accused. In the process, they may face conflict between law and ethics. So, for example, that there's a thing called attorney-client privilege. So the person that you're defending, when they tell you things, you can't share that with anybody. It's private information. And that's important because you need to have attorney-client privilege in order to, create the best defense for your client. But in the process of that attorney-client privilege, you might get knowledge of guilt, right? They might tell you that they did, in fact, commit the crime, right? A lot of times defense attorneys, they don't want to know one way or the other because, they just want to create the best strategic defense. But you may find that out and you still are obligated legally to defend that person. There might be a witness that is telling the truth, but that you could discredit the witness, call into question their character, their abilities, in order to vigorously defend your client. And so the conflict between law and ethics is something that defense attorneys need to be able to wrestle with and deal with in order to do their job. So the duties of a defense attorney are very similar to the duties of the prosecuting attorney. It's just that the goal is different. And so the goal is to provide a vigorous defense to the best of your ability to your client. And in doing that, they investigate the incident, just as the prosecuting attorney does. Any pretrial procedures, they represent their client at those trial procedures. They participate in plea negotiations, trying to get the best deal for their client. If they represent their client at trial, they'll provide assistance of sentencing at trial. offering like a lower sentence, like encouraging the judge to give their client a lower sentence. And then if there is an appeal, they would determine the appropriate basis for an appeal. So help the client to let them know what would, whether or not like it's worth it to appeal. And then if they do appeal, to represent the client in those appellate processes. Okay, so when the criminally accused, they have two options for a criminal defense. Okay, and so one of the options is that if they can afford to get an attorney, then they would get an attorney through what's known as the private bar. And the private bar is basically, that those are attorneys who are not. They don't get their income through the state, but they get their income, they make their living through people who hire them to pay for their services to represent them at trial. Now, keep in mind that when it comes to prosecuting attorneys are state employees or federal employees. They're paid by tax dollars, right? And so district attorneys, attorney generals, the attorney general of the United States, they're all, public employees, and they all get paid through tax dollars. That's not the case with defense attorneys. Some defense attorneys and, other attorneys as well, those who represent corporations and those sorts of things, an attorney can be in private practice, okay? And so the private bar, those are lawyers that you hire to defend you in court. However, if you are deemed indigent, in other words, if you're deemed by the state to be too poor to be able to provide for your own defense, the state must provide that defense for you. And that comes through the Sixth Amendment, the right to counsel, which we'll be learning about more when we get to trial rights. But if you can't afford an attorney, the state is obligated to provide one for you. So if you cannot afford your own attorney, there are different systems for assigning defense to those who are deemed indigent, unable to pay for their own defense. And I'll just put these up here and we'll talk about each of these individually. And then you can read more about these different methods for assigning defense in your textbook. One major way is public defenders, and that's actually been in the news recently because the recently confirmed Judge Ketanji Brown Jackson, who just was recently confirmed to serve on the Supreme Court of the United States, she served as a federal public defender, and she got a lot of crap at the confirmation hearing for serving as a public defender, which is a little odd because one of our key provisions within due process in the Bill of Rights, the Sixth Amendment, is that you have the right to counsel, even if you cannot afford it. And so a public defender is basically like kind of a public law firm whose only clients are the criminal offenders, okay? And so the public defender's office, it's administered by the state. Wisconsin has, not all states, but many states have a public defender's office. In Wisconsin, it's the Wisconsin State Public Defenders. And so this is an option for if you go to law school, that one of the things you can do is you can serve as a public defender. And so it's an office that's dedicated to providing defense for those who cannot afford an attorney. Not all states have public defenders, and even if you have a public defender, you may not have enough lawyers in order to provide that defense because everybody gets a defense if they can't afford it. And so there's other systems for assigning defense for the indigent clients. One is assigned counsel. The other is a contract system. You can read more about it in your textbook. But assigned counsel is that there are attorneys that are part of the private bar, and that they can the judge appoints these private attorneys, so that if an accused comes forward and they don't have defense, then the judge will go to a list that basically says that they have an ad hoc list, and they'll go down the list and they'll say, okay, the next private attorney that's up that we're going to assign to this indigent client is X, and then they go that way. Sometimes it's more coordinated, that that there's a particular private law firm that is sort of working with the court system to provide that kind of defense for the indigent. Also, that contract system is where the state gives a block grant to a private firm. They basically say every year you're going to get X number of dollars, and then that means that you're going to provide defense for those who can't afford it for a set period of time. But you can read more about each of those in your textbook. So, in conclusion, I just want to let you know about an extra credit assignment that you have for and it's due up to the very end of the end of the semester, and you can earn 15 extra credit points for engaging in an online discussion of this great documentary called Gideon's Army. Gideon's Army is about public defenders. And so it's a 2013 documentary that follows the personal stories of three public defenders that live in the southern part of the United States. One is in Georgia, and they come from other places. And public defenders in the United States are underfunded, and they're particularly underfunded in the southern parts of the United States. So this is just a great movie. It shows the activities of three really inspirational public defenders: Travis Williams, Brandy Alexander, and then June Hardwick. And you can see Travis and Brandy are here. I think my pictures covering June. And it just shows how hard it is to be a public defender, but just how gosh darn dedicated these folks are to making sure that everybody gets a proper defense, even if you can't afford it. And it's called Gideon's Army because it refers to the landmark Supreme Court case called Gideon versus Wainwright that extended the right to counsel to all criminal defendants. So I hope you watch it. It's a great documentary. Plus, you can earn 15 extra credit points. Sorry this went on a little bit more than a half an hour, but thanks a lot for paying attention. I appreciate it, and I'll talk to you again soon.